Now, today, when we come to the topic directly, now most of us know what exactly is research. In spite of the fact that several definitions have been given about research, the number of scholars adding to this field is growing on day-to-day basis. As and when a book comes, some of them intend to refute what is being written there and intend to give an innovative idea. We are not interested in those things or in their politics or some other activity kind like thing. But research, generally speaking, is action. Now, why it is called as action? It is action for the simple reason because one naturally translates knowledge into action. When a knowledge is translated into action, the topic which is being chosen by him must be socially relevant. Unless the topic is socially relevant, remember, especially in the 21st century, it is not going to serve any purpose or anyone. What is being taken up by way of research should serve the society. I am not speaking about economic development only. Now, there are several areas, even in the area of law, wherein research is required. And when research is required, it must be in a position to see or to alter or to change or to improve the existing legal system so to serve better for the people of the country. That is where research gains importance these days. Now, when we speak about this, when we speak of research, always the concept of research and the research mind is accompanied by what we call as critical scholarship. Now, the critical scholarship, when you speak of a researcher, must be in a position to collect the documents wherever is necessary. For example, take it this way, I am asked to speak about 1.5 or 2 hours. So, unless I collect the documents, how I will speak? I cannot talk on the air because it should be on a particular problem. So, a true research scholar is one, he should collect the documents. Then, thereafter, edit the sources. See, for example, most of you will have come across one important thing. When you start collecting the documents, you will not be knowing. And most of the researchers feel even today, suppose, for example, eminent scholars start writing articles. When they start writing articles, they collect the sources, and the sources which they have collected may be of, remember, immense value. Although it is of immense value, you cannot add it in the article. Only a few pages or a few sentences or a few quotations may be put there to justify a point which is being taken up by a research scholar. That is where editing is one of the most important tasks, wherein he is not supposed to mislead the authority. He is not supposed to suffer from fraud's disease. Now, fraud happened to be FROAD, is a scholar. He would happen to be a brilliant scholar, but then he would speak correctly without one single mistake. But then the same person, if he was asked to put it in writing, he would commit murder of facts. A few of the scholars today suffer from this habit, and it is called as fraud's disease at a later stage. So such things should not be there because he should be a pure, genuine scholar. He should supply the sources, edit the documents, and thereafter, what is required to be done, it is done throughout. Now, in today's lecture, I shall just concentrate what we speak about action research. Now, what exactly action research? Most of the issues will be concentrated on action research. Then I will speak to you something relating to comparative social research. Thereafter, one prognostic type of research and creative research. Only these four issues will be taken up. And I will be giving you individual examples which are being given by writers of eminence. And all these illustrations which are given by them are very, very emphatic, and they are relevant, and they are to the point. Now, when we speak of action research, first and foremost, action research is one important thing. It is a social research. It is a social research. It is a democratic type of research. Then it is a developmental type of research, and it is participative research, and it is emancipative research. Now, mostly, if I was just going through a book wherein I was trying to go through the origin of action research. And the origin of action research relates back to the Second World War. So, during the course of the Second World War, many countries were destroyed, and many of the countries were facing scarcity. And this scarcity had to be met instantly and immediately. And you don't find time as well. In such situations, one of the scholars, remember, he went to the extent of pointing out that action research is the only remedy. Now, he was none but Kurt Lewey, Kurtlewi. Now, he was a social psychologist. And this Kurt Lewey, a social psychologist, was able to find certain solutions in overcoming the deficiencies in the system of the day. So that is where, at a later stage, it gained momentum and became action research. Now, first and foremost, every one of us should remember a remedy oriented research is action research. So when I speak of remedy oriented, it is for purpose of instantly giving a complete solution to the problem, to resolving the issues. And then remember the measures which are being undertaken, all of them naturally become action research. That is where when we speak of action research, it is a positive action and remedy to overcome the difficulties. That has to be noted by everyone. Now, what exactly are the instances which can be given today when we take up action research? Now, there are the writers will have given many of them, and one such illustration happened to be an instance which is being taken from the state of Bangladesh. Now, in the state of Bangladesh, rural poverty was writ large, and the people did not have money, especially they did not even have 10 tika or 10 rupees to meet their expenses on a single day. And in such cases, what was happening was the money lenders would exploit him to the hilt. And how these things are to be tackled was the problem which the state of Bangladesh was most interested, especially the planning department. Now, in such a situation, there was a person by name Muhammad Yunus. Muhammad Yunus happened to be a professor of economics. Later, he became a hero, all-time hero. Muhammad Yunus, as a professor of economics, was actually working in the University of Chittagong. And when he was teaching in the classroom, there was a chapter, poverty is writ large. Bangladesh farmer is born in debt, lives in debt, and dies in debt, like the Indian farmer. So these are the things which are being taught in the classroom. But then he wanted to know the true reason. And when he wanted to know the true reason, remember, he selected a few of his good students. Having selected a few of his good students, he goes to the village. And having gone to the village, he conducts a study. When the study was conducted, remember, it may be a survey. And a survey is naturally based on a questionnaire method. And afterwards, remember putting it down like any other research method which you have, which you know and well aware of. Later, he came to know most of the people live in poverty is because of the ruthless money lenders. And these money lenders, remember, even to prepare a bamboo stool, because bamboos are known in that area in Chittagong, and to prepare a bamboo stool, they would give money, and if money 10 rupees is given, in the evening you have to give them 20 rupees. What kind of development can take place in such inhospitable situations was the question. So he tries to analyze further, and having decided, he selects a pupil. He selected 20 women who are the poorest amongst the poor. Having selected them, he lends money from his pocket. And he says, whatever materials you intend to buy, and whatever equipments which you require, and for all the 20 people, I will finance. He financed himself. And afterwards, he just put 1% or 2% interest. And remember, they were not only able to produce the stools, bamboo stools, And these bamboo stools were sold in the market, and they made money, and the money was returned. So this was the first step that was initiated by this man. Having done this and it became a success story, he diverted this to other areas as well. So when it was diverted to other areas, you may ask me, which are those areas? Now, one is to the fishermen. They also need money on day-to-day basis because they will be on voyage and they may not be reaching in the evening at times. So in circumstances such as this, he prepared to lend money. So what he did was, in the second instance, he approached a few banks, and from the banks he remained as a guarantee, and the money was given, and it was again a success story. In the third instance, what was happening was vegetable vendors. Vegetable vendors naturally need money because I remember I see every day when I go to my office, KR market is the biggest vegetable market we can say in Asia. All the what we call is the sellers, even in the air conditioned markets, go there and buy vegetables. Remember, for this they require money. What about the poor man? He will maybe sitting on the streets, but then he need money, and that was given. And he later a Grameen bank came to be established. And the Grameen Bank, which came to be established, was in a position to serve this type of people only. It may be fishermen, it may be vegetable vendors and sellers, or it may be the other one. First one I just spoke to you, rural women. And it was diversified to many other areas as well. When you get to know, you come to know these things, how economic development has taken place. Now, this is when you find the problem, there is no point in discussing and leaving it there and going. Whether a solution can be reached, and if solution can be reached, in what way, in what manner, and how best it can be utilized. And later the government of Bangladesh intervened and was able to set up several Grameen banks. This is how economic development prospered in the state of Bangladesh. This was one instance which was given for purpose of action research by the text writer. Now the second instance, again a major instance, happened to be an instance from this state of West Bengal itself. Now this is relating to what we call as witchcraft and witch hunting, leading to human sacrifices. Now at times, remember, this is we I also used to read when I was in West Bengal, the type of activities which are severe, which are cruel, which are hard-hearted, which are stubborn. And it cannot be regulated that easily because anybody tries to regulate, remember, can be a sacrificial lamb and they will kill him instantly. In situations like this, the first thing is how agenda could be prepared. So the person says the agenda was actually prepared by inviting the best of the brains in this area. And the best of brains in this area naturally may be in sociology, in superstitious belief, and other economic development. All of them are pulled together and try to discuss threadbare how to go about. And in the meeting, they come to know these are certain things which have to be done. First is where you have to find out an NGO. And if the NGO is not there, it should be registered and employed. And only through the NGO, the people who are interested in saving these people and giving up the superstitious beliefs, the work should begin. So that is where NGO comes into the picture. And thereafter, several social workers go there into the spot. Having gone to the spot, remember, they will be very careful because they will not accept, the people are not prepared to accept these views because they will be considered as outsiders. And slowly and steadily they watch. And then having watched them, they mingle with them. And they try to speak to them, they become one with them. Thereafterwards, they prepare a questionnaire. And this questionnaire is being examined thoroughly. And then the data, actually, the data that is being prepared would help them. And they go to the NGO, and there the final step takes place. Then the solution that is being given is also being discussed. First thing is, especially the youngsters, you have to attract them to go to schools. And when you tell them to go to schools that easily, it is not possible. and you require a particular person who is responsible in managing. And where finance is required, it has to be done by them. So thereafter, they start going to the schools, and when you go to the school, when you interact with them, when you talk to them, and you try to elicit certain good ideas from them, you educate them, saying that superstitious belief are not part of our constitution or structure. And this was practiced by our ancient people, which has no relevance today. And by educating them, the slowly and steadily the picture can be changed. And this was done, and this is being done very actively even now in the state of West Bengal in Jalpaiguri. Now, the third instance happened to be an instance again which he gives from the state of West Bengal for action research. Now, what is happening is there were thousands of migrant women and children come to the borders of the state of West Bengal from Bangladesh. Having come here, they try to sneak into the territory of the state of India. And when once they become part of the Indian territory, remember, they are ruthlessly sold in the open market. And afterwards, remember, they will be taken to Madras and from there to the countries, maybe to the Gulf or to some other countries, wherever. Now, in such situations, how to contain these people? How to give them education? How to refine them? How to change their temper? These were a few of the questions that was faced by certain NGOs. No, you can't just go there and talk to them, because in spite of the fact that there are CRPF, you may be targeted and the concerned researcher may be killed at no time. So in situations of this kind, through the NGO, you go to the spot. Having gone to the spot, you just start collecting the data on these people by interviewing. So in situations of this kind, the opinion of the local people also matters. Then you go to the what we call a CRPF, because they have been managing it, and they will be having wonderful data which may not be known to anybody. It is best known to them. Either they support or they stop it. All these matters come to the picture, and it is observation, participation are the two important. Participatory research is most important, both in the earlier one, in the Jalpaiguri incident, as well as the present one. And once this is done, naturally you go to them, meet them, and talk to them. And you will be in their camp only, because there will be certain camps wherein these people are caught and put. And when once you are there, you'll be in a position to give a resolution, and a few of them at least will go back to their country. So remember Article 23 of the Constitution of India, how it is being flouted. And one of the places is this, which is happening in the borders of the state of West Bengal between Bangladesh and the state of India. And this has to be given a solution, and it requires a lot of funding also. And there are funding agencies through the government which come into and rescue the people. That is where most of the activities that is being taken here, being in a superb way, they are being tackled. Now, the other aspect which I just wanted to speak to you is one important aspect relating to a beautiful case which came before the Supreme Court of India. And this case happened to be R.D. Upadhyay versus State of Andhra Pradesh. And a few of you will be knowing about this case. The matter is, a small girl writes a letter to the Chief Justice of India about her mother who is put in the jail. So this case actually relates to the condition of women in prison and how best their conditions could be reformed. See, the point is the law is there, law is enacted, but then the law is not able to function effectively. And based on the letter which is being written by a small minor daughter, the Supreme Court took up the issue and started investigating. And all remember the senior police officers and the police commissioners and inspector and director general of prisons, remember, had a hell of time in submitting. And later the Supreme Court appointed a committee. And this committee, which was appointed by the Supreme Court, was in a position to grow threadbare and how to improve the conditions of women prisoners in India. No, this is again action research. This is only to find out a remedy, to avoid and put an end to the evil, to stop the ghastly atrocities which are being perpetrated by anyone. I'm not saying that it is done by the police officers, anyone, and even goons. That is where action research was, I remember, successful. Now, having said this much, I just intend to speak to you one more case. Now, you have a legislation which was enacted in the year 2006, Scheduled Tribes and Other Forest Dwellers Act of 2006. Now, here you have to first go to the need for a legislation of this type. And the need for a legislation of this type, if you just look into, remember, most of the people, what we call as the tribal people who are living in the forest, were chased away by, remember, big businessmen or money lenders, and they are not given their proper rights. In such inhospitable situation, remember, a committee which was appointed by the government looked into the matter. Having looked into the matter, they said the only way that is being left is to bring out a legislation that is known as the Scheduled Tribes and Other Forest Dwellers Act of 2006. Now, under this, you cannot do, nobody can intervene. No, however illiterate a tribal person in a forest area, you cannot just remove him out and throw him out and just say our job is over. No, the property is ours. No one can just trespass the land. And if that is done, the legislation come into the picture. The purpose of saying this, independent legislations have come in, and this has come in after what we call as action research, which is being done either by the Supreme Court or by the parliamentary committee. All investigations, only if it is complete, these legislations came into force. Now, one more case which is relevant today for action research happened to be in Banwasi Seva Ashram versus State of Uttar Pradesh. In Banwasi Seva Ashram versus State of Uttar Pradesh, the Supreme Court intervened the matter. This is a case relating to National Power Thermal Corporation of India. Now, what has happened was tribal forest people from Uttar Pradesh, Banwasi area, were simply sent out. And they have not given them alternative land at all. There was no alternative accommodation or land. It was at this juncture the matter was brought before the court of law. And the Supreme Court was, remember, requested to look into the matter. And the solution should be found. And the solution should be implementable. That is what it says. And they said, National Power NTPC, the Power Thermal Corporation, while taking up the issue and while taking up the property for purpose of establishing thermal corporations, just should allocate other lands to the people whose land have been taken away. So this is where improving service conditions to the people came in for the first time. Now, thereafterwards, I just wanted to speak to you action research in the area of environmental law in this country. And in this area, remember, wonderful work has been done. There are two cases exclusively dealt with this, and it is based on action research. Unfortunately, most of the books in environmental law not even make a mention of these two cases. And I shall just tell you briefly the facts of the cases and the decision and the steps that are being initiated by the Supreme Court of India in these cases. Now, one happened to be the Birchi case. Birchi happened to be a place in Udaipur or the state of Rajasthan. Now, before that, I shall just tell you the events leading to the concerned case. Now, what has happened was the European countries, remember, was just trying to put an end to the circulation of H acid. And H acid, remember, is full of naphthalene. And this H acid, which is full of naphthalene, is being used only for putting colors on what we have clothes. So when they were putting an end because of the dangerous, deadly, dangerous and devastating effect of this, they wanted to put an end to it slowly and steadily. Both India and China realized the problem. Having known about this, they grabbed it and slowly and steadily in India, remember, there were factories which are set up producing only H acid. So one such a factory was established in the state of Rajasthan. And this factory, which was established in the state of Rajasthan in Birchi in Udaipur, now what has happened is the next. This factory in Udaipur in Birchi started producing H acid, and it started producing what we call as the deadly chemical. And the production of the deadly chemical, remember, immediately polluted the water, and all the bore wells or the wells were polluted with militant red color, and they were poisonous. Thereafterwards, there were irrigation canals as well. And these irrigation canals were also flooded with what we call as this deadly color, and it reached groundwater and polluted the groundwater as well. In such circumstances, the people, remember, got up from their deep slumber. What is happening? How we can drink this? How we can make use of this for purpose of taking bath or for purpose of cooking? And water was deadly. And all of them, as usual, they marched out of the deputy commissioner's office. The deputy commissioner's office was not in a position to give a solution. He said the industry should be closed. And this has taken place in 1989. Then what has happened was the prime minister of the country reached, he said all the factories to be closed and it should not be allowed to function. But that did not take place. In the meanwhile, what has happened was a member of the Pollution Control Board of India visited this place. Having visited this place, remember, he saw that some kind of expert opinion is required. So at that time, what has happened was one of the universities from the same place and another Aligarh Muslim University, both universities joined and appointed scientific experts to go through. And these experts submitted reports and they said it is deadly and the factories to be closed. I don't want to go into the intricacies of it because a lot of things are just said there. Now, in this situation, a petition was brought before the Supreme Court of India under Article 32 of the Constitution by our popular MC Mehta. And he said, what should be done? Why it is being allowed? And the Supreme Court immediately issued notices to the Pollution Control Board of the state of Rajasthan, issued notices to the Deputy Commissioner of Birchi, issued notice to the Central Pollution Control Board as well. Now, having gone there, they said, now it has to be examined immediately without delay. And having, without delay, they were able to submit a report, and a report indicated that the factory shall be closed. Now, instructions were given. The Supreme Court gave an instruction saying that the Rajasthan Pollution Control Board should go to the spot and submit a report to the Supreme Court of India in 24 hours. In the meanwhile, when notices were received by these industrial owners producing H gas, what has happened was they started quietly shifting to neighbor areas. And the neighbor areas also got polluted. And the sludge that was found, remember, is inestimable. And remember, the loss that was caused is beyond human imagination. Then the pollution control boards, the central government and the state government, both were coming, and the Supreme Court gave a judgment. And the judgment came in 1995. And in the 1995 judgment, they said the entire thing will be ordered to the earlier position, status quo ante, and for which the concerned industries were responsible in polluting should pay a compensation to the tune of 44 crores. First they said 40 crores, then it was extended to 44 crores. It was, I'm telling you, 1995. Now, other important case happened to be, is also not spoken by anybody, but this is the most important case relating to hazardous waste and substances. Now, I came to know about this case very recently while valuing a PhD thesis from Jawaharlal Nehru University, who was working on hazardous waste, wherein on these two cases he has written a chapter, and the chapter was so beautifully written. I shall just explain to you the Research Foundation case. This case is popularly known as the Research Foundation case. Now, in this Research Foundation case, what has happened was the state of India became a party to the Convention on Hazardous Waste, the Transboundary Movement of Hazardous Waste Convention of 1989. It came into force also in the state of India. Thereafter, the management of hazardous waste rules were also incorporated and adopted by the government of India. But in spite of the legislation, hazardous waste were imported to the country without prior permission. So when I speak about prior permission, without prior permission, they are being imported and dumped. Although in most of the cases prior permission is required, they are imported, and how they came, from where they came, what is happening, nobody knew. And it was at this juncture Vandana Shiva brought what we call as a public interest litigation before the Supreme Court of India. And in this public interest litigation, she just pointed out most of the rules and the legislations relating to hazardous waste is flouted on day-to-day basis, and we don't have a dump site. And a dump site, remember, are being filled with, if it can take 3 metrics, there will be 300 metrics which is being put inside. And it is an environmental disaster for everybody. What should be done? And the Supreme Court should take up the matter and hear. And the Supreme Court immediately seized the opinion, and after 2 hearings, it found that a committee of experts should be appointed. You will be wonderstruck. The Supreme Court heard this case, remember, 174 times. It came up for hearing 174 times. And the case actually was decided, although it came in 1995, it was decided in the year 2012. And every time when it was heard, they were doing something new. And it was actually action research to save Mother Earth and to save the natural resources of our country. This is the only thing I can say. The Supreme Court having appointed a committee under the chairmanship of a great person, MGK Menon. And this person was asked to look into the matter. And it was a 7-member committee. And this 7-member committee, remember, took 4 years to look into the whole aspects relating to hazardous waste. 4 years. And remember, in 2002, it submitted the report, and the report contained 1,000 pages, running into 1,200 pages. Now remember, there were 14 tasks which are given to the committee. And the committee was asked to look into 14 tasks. Now we were interested to know what are these. Now first one is look into the hazardous waste definition. When we look to the hazardous waste definition, each country is empowered to adopt a definition of its own. It simply says, adopt a definition of your own. And most of the definitions which are adopted by the countries are hazardous, because it will create environmental pollution. Now, how we can have a uniform, acceptable, pollution-free definition? This was one. And it has to be given to the subject experts. They cannot draft on their own. Then it said, even a state, the OECD members, Organization of Economic Cooperation and Development, OECD members, when you look into the document, they were also freely exporting what we call as industrial sludge and other things for purpose of dumping into the state of India. And the records indicated nobody gave the consent, on its own it is coming. How it can come without the approval of someone? Pollution departments were totally silent on this. Now, in addition to this, how to tackle this problem? So there is prior informed consent, which is being part of the Basel Convention of 1989. How this convention could be enforced in stricto sensu? What exactly is the role of the what we call as the officers of the Ministry of Environment, both of the state and central? Ultimately, remember, the committee visited almost all the major factories in the state of India. That is why it took 4 years. They did not leave any of the factories, and the report clearly indicates this is the problem in this is the problem. Now, what has happened was one important thing which they found out happened to be relating to small-scale industries. Now, these small-scale industries, remember, they are the largest contributors to pollution. Since they are small scale, what would happen is, remember, they will release what we call as the hazardous substance in the waste then and there only, and there is nobody to take care of. And one of the reports written by, in one of the chapters written by MGK Menon points out, especially in small scale industries, what they would do is, now remember, a road will have a dead end in some roads, and after the dead end, you don't have anything, and there will be steep also. And in this steep road, they will release it and will go near the dead end, and it will be polluting and creating so much of problem and contaminating groundwater resources as well. Now the other thing is, they wanted to know matters pertaining to landfill. Now one of the horrors is indicated in this report happened to be, till 1997 there was hardly any landfill recognized by the government of India. Till 1997, there was hardly any, not even one landfill site recognized by the government of India under notification. And most of the landfills which are established are only for temporary purpose. And these landfills which are, remember, established only for three months to unload the hazardous substance, who has been unloading hazardous substance for almost 30 years. Imagine, where is 3, where is 30? So how this could be put an end was the question, and the answer had to be given by them. Now then, they went to the extent of pointing out pollution control boards. One chapter speak about the pollution control board, and when it said the pollution control board officials, remember, most of them are not qualified to become. They don't have any knowledge of the concept of pollution at all. They don't have any knowledge of the concept of pollution, but still, because of the government and the influence and the clout they have become members of the pollution control board. So these are to be avoided. Only competent men should come there to become the officials. Then it speaks about, in one of the chapters, it speaks about the inspectors in the airports as well as in the ports. And these inspectors, who are specially appointed for this purpose, have no knowledge of anything, neither hazardous substance nor hazardous waste. What is it that they are going to do? And this is for purpose. That is why the tasks were given, and they have pointed out, and they gave the solution how it should be resolved, and what should be done, and what action should be initiated. That is why this is one of the best, remember, case for purpose of action research. And you have wonderful judgment which is being given. And the report of the committee, a major report of the committee, is part of the judgment as well. So that is where the industries from hence, that is after the judgment which was given in the year 2012, are supposed to implement it come what may, was the expression that is being pointed out. Then one more thing, the concluding part of this is, they said all hazardous industries may be related to waste, or maybe related to hazardous substance, should put through online what is hazardous and what kind of activities are being carried out by them. And this should come to the common knowledge of a bypasser even. And they should know this industry does this job, and it is mandatory. And especially those who indulge in, especially in carbon, in sulfur dioxide, they have strict restrictions. More, the restrictions are very severe. That is being pointed out. Now the point is, you may ask me a question: what exactly are the developments have taken place after this report? See, this is first is they investigated, and they took 4 years, and all eminent men, not hardly there was any person who did not know anything about environment science and law. And the report studied everything, and they submitted it. And after the submission of this report, remember, major, you might be knowing, the hazardous waste rules came in the year 2016. And it is because of this, nobody makes a mention of it. Because most of the decisions which are being put there, or the recommendations which is being put there, is a part of the comprehensive rule which was adopted by the government of India in the year 2016. And you think of it, after 2012 and 2016, there were several other legislations came in. And most of it are, remember, influenced or impacted by this kind is the point which I just wanted to harp upon. Now, having spoken something relating to action research, I just intend to speak to you something relating to action research in international law. Now, I was just thinking in the last 2 or 3 days after Professor Bhatt spoke whether in international law whether this was there. Now, I there are 2 or 3 cases which I just intend to highlight, especially the students of international law would benefit. One such a case happened to be a case which came in before the International Court of Justice in the year 1990. You may be knowing that the state of France wanted to explode nuclear weapons in 1973, and they wanted to explode the nuclear weapons in the Pacific. And when they wanted to explode the nuclear weapons in the Pacific Ocean, both the state of Australia and New Zealand go before the International Court of Justice. Having gone before the International Court of Justice, they said, we are not only representing the state of Australia and New Zealand, but we are representing the global commons, because the nuclear deposits which are caused or released because of the explosion may reach the coast of Australia and New Zealand, and it may be in a part of the high seas, and it would, remember, imperil the freedom of navigation as inscribed, indicated in Article 87 of the Convention on the Law of the Sea. Now, thereafterwards, remember, the matter was closed there because the state of France said, no, in future, we will not be able to carry on nuclear plus, we will not be doing it. But in 1990, again, the issue came up before the International Court of Justice. The state of New Zealand got the information that the state of France is going to explode another nuclear weapon somewhere near the Pacific, and it is going to hit the Pacific region, and afterwards devastation may cause to the people and the basic, what we call is the nature and resources. So at this time, New Zealand goes before the International Court of Justice and submits an application. And in this application, submitted by the state of New Zealand before the International Court of Justice, it requests the International Court of Justice to pass an order and serve on the state of France. And what is this order? What exactly the content of this order? It is simply said, in the event of exploding a nuclear weapon, prior to its explosion, there should be an EIA, environmental impact assessment, has to be conducted. And without conducting an environmental impact assessment, remember, the state of France, without showing the report, and only after showing the report to the International Court of Justice, then examined by the ICJ, then it can think of conducting, not before that. Now, the International Court of Justice, remember, at that time, they said these are all complicated matters, we don't have jurisdiction. Now, although they said they don't have jurisdiction, there were 3 judges. This is the fundamental point. There were 3 judges at the International Court of Justice who gave dissenting opinion. What they dissented, what they said, on what grounds they dissented today became true international law. That is why one who writes a dissenting judgment will also have a vision for the future, a vision to save the succeeding generations from catastrophes. Now, 3 judges, you may ask me, one is Justice Palmer, and the second one is Justice Veeramantri, and the other one, third, happened to be Justice Koroma. Now, Justice Palmer of the International Court of Justice in this case pointed out, you look to the establishment of the 1972 Stockholm Conference. After the conference, Stockholm Conference, and the establishment of the United Nations Environment Program, and the subsequent developments that has taken place up to 1991 on the date of hearing by the International Court of Justice, a lot of developments have taken place. And these developments may be World Charter for Nature 1982 or the Sustainable Development Document of 1985, saving the succeeding generations. And then the protocol relating to prior informed consent to other states. All of them, I am not going to speak any of them because that it will consume time. have developed what we call as certain norms of international law. And these norms of international law today are accepted by states. In these circumstances, prior informed consent also has to be what we call as EIA. Environment impact assessment has to be conducted by the concerned state. Without an environment impact assessment, remember, nothing can proceed. And this is only to save that state and other states who are members of the United Nations. Now, what did Veeramantri point out? Now, Veeramantri, remember, very harsh. He went to the extent of pointing out. Remember, EIA is essential and it is fundamental. And today it has taken the today environmental law after 1972 to 1991. Certain principles have gone to that extent where it can be considered as jus cogens, a norm of international law from which derogation is not permitted. This is what Veeramantri in his judgment has pointed out. I was just reading an article written by Professor B.S. Chimney, and this is related to research international law. And in research in international law, what he points out, he was just citing a particular case. And this is relating to the Gabakino case, which was decided by the International Court of Justice in 1997. What he was saying is, along with the tenets of Islam, along with the tenets of Christianity, remember, the other tenets also should be considered because there are certain common principles. And these common principles in every religion are commonly applied. And what harm is there if these principles are taken and noted and put in a judgment of this nature? This is what he was saying. This is where he was saying, remember, it is one light which was coming from Asia, from one of the Asian judges, and which has to be respected by everyone. So the point is, the other person, the last one, Koroma. Koroma is the man who just pointed out, let us not go into all these issues. Let us just go to the Stockholm Declaration. In the Stockholm Declaration, we have a principle which is known as Principle 21. What does it say? Principle 21 of the Stockholm Declaration simply says, states have the sovereign right to do what they want. But then if they have the sovereign right to do what they want, they are not supposed to harm the environment of other states. And if they harm the environment of other states, and it will have an impact on the environment of other states, naturally there will be liability. And for which he just pointed out, you will just look to the trial smelter arbitration case. The trial smelter arbitration case, which was decided in 1937, it came 3 times. It came. 1937 happened to be the final one. Now, for example, the state of Canada was releasing noxious fumes led by zinc, lead, sulfur, and it was entering the Columbian River Valley and to the state of Washington. When it entered the state of Washington, it destroyed standing crops, and it destroyed fishery resources. It destroyed forest culture. So at this juncture, they said, remember, for the loss that you have caused because of releasing these fumes, you are answerable. And he was saying, right from 1930s, this principle has been accepted, and today it has become part of municipal law. And if this has become part of municipal law of every state, today this principle 21, has become part of international law. It has become part of international law because principle 21 is repeated in Article 2 of the Rio Declaration. And Principle 2 of the Rio Declaration has been repeated in Article 3 of the Convention on Biological Diversity. So when the situation is like that, there is no escape. States cannot do it. See, this is action research, how it impacted. Naturally, remember, impact assessment research is rare in law. It is very difficult to find. But here you find a case wherein impact assessment, how the International Court of Justice examined this and went to the state and quoting rules right from the trial smelter arbitration to the 1991 decision. This is one case. Then the second important case, which generally speaking, nobody tells in the classroom. But this is an important case for every one of us. Now, this case is popularly known as what we call as the effect of awards to the Administrative Tribunal of the United Nations. I shall just tell you in two or three sentences about the prehistory of this case. Now, what has happened was the United Nations came to be established in 1945. After the United Nations came to be established in 1945, remember, they established, the General Assembly of the United Nations established a tribunal. And this tribunal, composed of several members, will look into what we call as the contract of service of the employees of the United Nations. In order to look into service, in order to look into the contract of service of the employees of the United Nations, the tribunal came in. Now, what has happened was the employment orders generally are given by the General Secretary of the United Nations. And the General Secretary issues the order, there the matter ends. Then they will get the salary, it will be credited, everything. Now, what has happened was in 1946-47, some of the United Nations employees, when they were working in service, they had leaked out certain information. Now, this is much against professional conduct. They are not supposed to do it. And immediately, remember, the Secretary General of the United Nations swung into action because they were very powerful in those days. The first Secretary General, Trigili, then all of them, very powerful. Then, in a few of the cases, they say well-founded. And 11 of them, of the 11 cases, a few of them are dismissed and a few of them are suspended. When the United Nations employees were suspended, naturally for the enforcement of the contract of service, they go to the International Court of Justice. First, they went to the administrative tribunal. When they went to the administrative tribunal pointed out, in a few cases, they are well-founded in 6 of them. And in 3 of them, compensation has to be paid. And in the remaining, they have to be restored. So the compensation amount which was supposed to be dispersed by the General Assembly was, remember, a few lakh dollars, not 1 or 2 rupees. And General Assembly was not prepared to commit. And remember, this came to the General Assembly for purpose of approval. So the decision of the administrative tribunal came back. And when it came back, the General Assembly said, we are the ones who constituted the administrative tribunal. Since we have constituted the administrative tribunal, whether the judgment of the administrative tribunal is binding on the General Assembly, what nonsense is this? We are not going to respect the judgment of the administrative tribunal. No, when there was a deadlock, the Secretary General, remember, prepared 2 questions to the International Court of Justice for an advisory opinion. And the International Court of Justice was supposed to give an advisory opinion on this matter. And what exactly is the decisions of the ICJ? In the advisory opinion which was given by the International Court of Justice, they pointed out, look to what we call as the debates of the United Nations. If you look to the debates of the United Nations, it is indicated by the makers of the United Nations that there should be appointment of officers who are above rapport. Their conduct cannot be questioned by anybody. They should have such integrity and they should be superior to anybody. They should not listen neither to the state where they are functioning nor to anyone. And they should take orders only from the Secretary General. To keep up the standards, efficiency, integrity, honesty of these employees, and to look into their efficiency, honesty, and integrity, there shall be an administrative tribunal. And this administrative tribunal shall be appointed by the General Assembly. And this administrative tribunal should be a judicial organ, not an administrative organ. So this they said, what is indicated there? In the Travax preparatories, if you just look to, remember, it is a judicial organ. And International Court of Justice, in its advisory opinion, pointed out, a judgment which is given by the administrative tribunal is res judicata. It cannot rehear. So it cannot. You cannot ask the administrative tribunal to rehear. It is not politics. It's a judicial organ. So this was, remember, the point which I am telling you is, Because since most of you may not be international law students, it had wonderful influence and impact. And it had impact even on municipal law also, and especially in the American theater, the Western theater. The purpose is the judgment which is given by an administrative tribunal, that is by a judicial organ, is a res judicata. It is binding and it cannot be reopened, it cannot be heard. And stick to and approve the compensation. This they said to the General Assembly of the United Nations. That is where, remember, these are a few of the cases which naturally impact every student of international law in its development. Now, one more point which I just wanted to harp upon. Uh, During the course of the expenses that are incurred during the functioning of the United Nations, especially in maintaining peace and security, the question came in: the missions relating to peace and security should be appointed by whom? Is it by the General Assembly or by the Security Council? Right from 1949, because of the differences between the Security Council and the General Assembly, the Security Council was not able to act because of the East-West rivalry. And when it was about to be reached to a flashpoint, the General Assembly intervenes. Having intervened, it appoints peace commissions. And these peace commissions, to solve the situation, to suspend the hostilities, to go to a particular spot. Having gone to a particular spot, remember, they suspend the hostilities. And these expenses which are incurred naturally became part of the budget of the United Nations. And Soviet Russia said, remember, we are not going to approve this, because here is a case wherein the General Assembly has overtaken the powers of the Security Council. It has usurped the powers of the Security Council. What the Security Council should have been done is done by it. And when the deadlock was prevailing there, the matter goes to the ICJ. And ICJ, in its advisory opinion, looked into the powers of the Security Council as well as General Assembly. Remember, this is actually, it is action research. The International Court of Justice must have done so much of research. Unless you do so much of research, they cannot write a judgment like this. Now, what exactly is the judgment? Before writing the judgment, remember, they read Article 24 and 25 of the Charter. Article 24 and 25 of the Charter of United Nations points out, remember, prime responsibility in maintaining peace and security rests with the Security Council. What is that? It is the prime responsibility. It is the Security Council which should maintain international peace and security. Then they started saying, suppose, for example, an organ is established only to maintain peace and security. But that organ, because of some inherent defects, is not able to maintain peace and security. Because of the veto, it fails to rise to the occasion. So in such circumstances, could there be any position? Could there be any provision under the Charter of United Nations? They said, prime responsibility is with the Security Council, but not the exclusive responsibility. You are supposed to act. If the Security Council fails to act, remember, the matter through the Secretary General could be put in the agenda of the General Assembly. Remember, in those days, such a judgment, when it was given, it was admired, appreciated. Articles were written, books were written on this subject. That is how it led to the development of the law of United Nations. Now, let me speak to you something relating to what we call as the prognostic type of research. Now, prognostic type of research simply means based on the present set of facts, present set of circumstances, present set of the prevailing legal system, what is going to happen in the years ahead. That is why now this type of research is gaining momentum throughout the world. It is gaining momentum throughout the world because there are a few cases, a few studies which are being conducted, which have led to the development and progress and prosperity of those countries. Now, when we speak about prognostic type of research, I will give you about two or three illustrations. And remember, everything is dependent upon what we call as the social scientific data. This is social scientific data in a particular state has to be analyzed thoroughly. And when it is analyzed thoroughly, you come to know what should be done, what should not be done, and what exactly is the resolution and a solution for the problem. I will directly start with the Karl Marx. Now, Karl Marx, most of you know, maybe better than me, happened to be a German. And this person, being a writer of eminence and to a certain extent a great economist, was just like a layman watching what was happening in the state of Soviet Russia. And when he was watching what was happening in the state of Russia, he was just looking at what was the Tsar doing there. And the Tsar's arrogance and the Tsar's ill treatment of the proletariat was known, and everyone came to know about it, even in Europe. And he's the man, having known this, he just find out whether it is possible to put an end to this immediately. Then he says, since the law machinery, law making machinery, enacting machinery is with the Tsar, it is difficult for the people to revolt because they will come and curb and suppress instantly. With the result, nothing would happen. And the proletariat will be crushed. That is what he was saying. But then there will be what we call as the kind of a fight which was going and which is likely to take place between the Tsar as well as the proletariat. This is not going to stop. Remember, if the Tsar or the administration or the ruling class or what we call as the upper class, if they tried, who are part of the administration, he tried to snub and suppress and eliminate, they again the proletariat unite. And the proletariat unite to such an extent, remember, they will be one day will be in a position to overtake. And they will establish what we call as the communist society of the future. So he wrote what we now call as the Das Kapital and the Poverty of Philosophy, one in 1846 and the other one is 1848. The Das Kapital as well as the Poverty of Philosophy went to the extent of pointing out the fight between the bourgeois on the one hand and the proletariat on the other is constant and it is perennial and it will be continuing. And it will come till the last, till the communist society of the future was established. I'm not speaking about the Marxian theory at all. I'm speaking research methodology. Now you think of it. He said in 1848 in the book, raised it in 1846. After 60-80 years, in the year 1917, the Bolshevik Revolution took place. And the Bolshevik Revolution changed the entire machinery. Where is Tsar? Tsar disappeared once for all. And new economic policy came to be established. The Communist Party of China took over, has been taken over by Mr. Lenin, and he became the General Secretary of the state of Soviet Russia. The point is, I'm not interested in saying, you think of the imaginative mind of the scholar. He sits in a particular place and thinks about the society. He thinks about the economic conditions. He thinks about the ruling class. He thinks about what we call as the palpable, miserable ill treatment that is being meted to these people. And they are not even honored, respected, admired. They were used like tools and booted on day-to-day basis. But then, remember, they have the same language. They have the same mind. And ultimately, in 60-80 years, they will be able to replace one great man. What we call as the Tsar family itself was wiped out from the map of Soviet Russia. This is the best illustration that is being given for what we call as the prognostic type of research. Now, the other one instance happened to be just during the course of the beginning of the Second World War. You must have heard of H.G. Wells. H.G. Wells happened to be a great historian as well. In 1937, he wrote a beautiful book which is known as The Shape of Things to Come in the Future. And in the first part of the book, he is analyzing on what we call as the age in the preceding years maybe 200, 300, from the age of Renaissance to Reformation and to revolutions and to the First World War and the beginning of the Second World War. And he was saying in these ages, remember, everything is made of iron is common. And utensils are made of iron. Aeroplanes are made of iron, if at all which have come. And rails, everything, iron, 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 all of them. It was called as the Iron Age. Here is a man who has just said, the Iron Age is going to come to an end soon. And the Iron Age is going to be replaced by the Plastic Age. And the Plastic Age, remember, when it comes, everything will be made of plastic. This is said in 1936. What has happened after the Second World War? And what is happening? Even the computer chips are attached to the instrument by plastic. This is where, and you will be in a position to elaborate many things on this. So, Iron Age is going to be replaced by the Plastic Age. This is what we call as a prognostic type of research. Now, there are many instances or illustrations. Because of the paucity of time, I don't want to dwell on these things because these are a few of the illustrations that is being given. Now, another research happened to be what we call as the creative research. Creative research is the imagination of the mind. Imagination of the mind. The imagination of the mind should be such, remember, you will not be able to even think of it, how the thought process actually occurred to him in his mind. They will be so fast. Now, one instance I will give you so that you understand the point instantly better. Now, one person, you know it, it's F.M. Hussain. And you have, who recently passed away, another person from Goa, Mario Miranda. Both are artists. And if you call them to honor them to a function, they will be, if you ask to give a chalk piece, they will go and draw a line. Having drawn a line, 2-3 lines, then afterwards they will speak for 3 hours on that. And he will give convincing answers. And these answers which are given, remember, nobody can challenge it because it is without dispute, with authority. By quoting original shlokas from the ancient books, they will say, this is how it is being done. Good or bad, that apart. Now, Mario Miranda, I have seen him because I was working in Goa as a professor of law. Now, once he was invited, then afterwards to satisfy the students, he drew a line. And afterwards, 1 hour he spoke, and there was so much of hilarious laugh. And everyone enjoyed to the brim. Now, what I'm saying is, this is what we call as creative research. Imagination of the mind leads to a process wherein it gives a solution to a problem. Now, there are, for example, you take an instance relating to the dancers and singers. Now, take it this way. You have many of the dancers starting from Hema Malini. She's not left dancing, although she's dancing now also. Or the other one, many you have, Padma Vibhushans also, this category. See, you go and sit there for 2 hours or 3 hours and they dance and they keep dancing. And people keep clapping and remember, enjoy. But when people keep clapping, they don't even bother about it. It is unheard by them. Because naturally the process of their mind in accordance with the song, how the step should be changed. And if it is taken in a particular way, then only people will appreciate. They will be listening to the videos only after having gone back to their room or place. They are not bothered about it because this is creative. Because when they were taught this dance or for sing or a classical song, they are taught it should be sung in a particular way. And if it is sung in a particular way, you are justifying the raga which you are singing. That is what we call as creative research. Many, remember, articles have been written on this subject as well. Now you take another person happened to be Leo Tolstoy. Leo Tolstoy now wrote a small couplet, and this couplet had only 8 lines. And this 8 lines, remember, was able to fetch him with the Nobel Prize. I shall just tell you the story. What is this story is all about? It is the story of a hard-hearted, cruel lion and it is being caged. The lion which is being caged, remember, you know how cruel it is. And every day at the appointed hour, one particular person comes there and he will be putting inside a pup. And soon afterwards, he will close the door. As and when the pup is put inside and the cage is closed, the lion will jump on it. And at one go, it will be killed forever. That apart. Let us not describe and venture into it. Now, here is a person who says this is relating to the daily food. One day, what happens was one innocent cup was put inside. And when an innocent cub was put inside, remember, the cub was not knowing for what purpose it was put there. Is it for simply the mouth of that lion or for some other purpose? It simply jumps on the back of the lion and starts playing with it. Now, instead of remember jumping on the cub, it develops friendly relations. And the friendly relations lasted for some time, about 6 months or 7 months. And afterwards, one fine morning, the cub dies there. Not because of the lion, because of some skin disease. Remember, the impact of the lion was such, it did not take anything and went into self immolation. That is the story. And this story came in 8 lines. Now, I am just telling you how he thought of it. And the second thing is how this is being put there. And this is being put in just 8 lines. That is why he is Leo Tolstoy, not anybody else. No, I am telling you, this is one of the best research minds in the world then. And one of the best research minds having known, because he must have described the cruelty of the lion and the innocence of the cub. And thereafterwards, the meeting point between them. And thereafterwards, the relationship. And then the instant inevitable death because of the disease. And thereafterwards, remember what we call as it leaves everything and leaves this world once for all. That is another type of the last part of the story which I just wanted to speak to you. Comparative social research. Now, comparative social research naturally helps to know the shortcomings in a legal system. So, in order to know the shortcomings of in a legal system, you should have a comparative legal research. Now, generally, comparative legal research is not done, rarely done. Only in exceptional cases, this is being followed. I will just intend to give you two illustrations and then go. There are many instances which I can give you. One instance happened to be an instance which is being given by Levelin, the great jurisprudence writer. And another one which was given by another writer, which I forget now instantly. Now, one instance happened to be, first instance happened to be the instance of Voltaire. Voltaire was a great writer. No, you forget, he was a great writer. He was a great observer of things. And this observer of things was just, remember, looking to the society in which he lives in the what we call as the 18th century. And in the 18th century, the society of the state of France, remember, was very miserable. After the death of Louis XIV, the state of France was actually, remember, taken care of by weak rulers, and they were not able to administer properly. With the result, everything was exploited by the ruling as well as the nobility. And in situations like this, what we call as the opportunities were exploited by the clergy, the nobility, and the ruling class, naturally made the people poorer. And the people did not have any voice. Their conditions became miserable. And one of the writers, I can give you one of the writers, he points out, when the crop was about to be harvested by what we call as the poor people, peasants, inside the wheat field, they would take horses and run and destroy the crops. That was the attitude of nobility. So in such a situation, he writes The Spirit of Laws. And The Spirit of Laws, remember, such a great book in those times, because John Gutenberg is the one who invented the printing machine. It was only a few years then. it came, maybe 100 years. It ran into, Spirit of Laws ran into 21 editions in just 18 months. That was the popularity. And the people of France read and read, and it gave so much of enthusiasm to rose in revolt against the nobility and the ruling class. And the ruling class was eliminated. Now, the last instance which I just wanted to speak to you happened to be the other great person who is known as Rousseau. Now, he was part of the system like any one of us. He was a great observer of the system. And he was just, remember, watching the society in which he lived, what was happening, how innocent people were made to work. And these people were given nothing. And then he writes the beautiful, what we call as the social contract theory. Now, one of the writers, H.A.L. Fisher, points out the first 100 pages of the social contract, that is, man is born free, but everywhere is in chains, lit the fire of French Revolution. Lit the fire of French Revolution. That was the impact. No, that was the impact. And they said, but for the social contract, there would not be a revolution of this type. And everything was changed. Everything was changed because they were seeing what was happening in the state of England and what was happening here. And they said, incompetence of the government, incapacity of the successors of the Grand Monarch Louis XIV, despicable sort of class privileged, lamentable destitution of the unprivileged, scandalous life at the palace at Versailles. All these things are to be replaced. And the time has come, you replace it. And the people rose in revolt. This is where one of the historians points out. He is known as J.R. Marriott. Revolutions rarely come suddenly and never by chance. Revolutions rarely come suddenly and never by chance. An accidental spark may fire the train, but the train itself must have been long and carefully laid. This was the message which was given by him after the French Revolution, after 100 years. So this is how, remember, what we call it the social science research will have an influence and impact. One last illustration happened to be in about impact research. What is this impact research? See, during the course of the Industrial Revolution, everything got changed. Women started moving out. They started working out. And they got long working hours. They would reach at home in the late hours. Early in the morning, they had to drive. So at that time, assertion of rights and the concept of rights and duties began. So here was a person at that time by name Charles Dickens. Charles Dickens, remember, was watching everything, what was happening during the course of the Industrial Revolution. And he was just, remember, having seen this, he was able to produce many books, and two of them, A Black Hole Tragedy in London, is one of them. And the second one happened to be David Copperfield. In these two books, he highlighted the difficulties faced by women during the course of the Industrial Revolution. And these difficulties have to be resolved. If it is not resolved, remember, there will be action by the people. And the people will, remember, try to replace this. That is where what we call as the parliamentary reforms came in after 1832. So this is what we call as a book written by, the books which are written by David Copperfield had so much of impact on the very social structure, wherein the parliament has to come forward. And they came forward and enacted what we call as the Law Reforms Act. Thank you very much. If you have any questions, if I know, I shall answer.
Yes, if Sandeep can.
Yes, please. Arup,
Yes.
you can go ahead. Thank you.
Sir, Arup here.
Yeah, good morning. Good afternoon.
Very good afternoon, sir. So it was nice to hear about all the specific issues regarding the action research. And you have taken lots of areas for like discussion, and which interests to me a lot about like the Stockholm Declaration you have mentioned very categorically in terms of the environmental issues regarding the cross-border atmospheric pollution also you have spoken about in these specifications. So when we go with the action research perspective, sir, my question would be like, if it is possible to look into the research methodology at the same time. For example, in what way can action research be used to evaluate the impact of legislation and policy, uh, basically policy and legislation reforms on marginalized communities so far? It could be Indian perspective or global perspective. So, in what way can action research be used, sir?
See, the first part of the story is regarding your question. Uh, there should be a research wherein what exactly is the present law regarding marginalized section of the people, and thereafterwards, based on the contemporary influence from other legal system, what exactly the measures which are being given to protect them, and then these measures which are undertaken are implementable. Just because, remember, the Western concept of human rights, all they say in human dignity, but that human dignity is entirely different in this country. That is why I said it should be of an implementable nature. First, you examine the law. That is what, remember, since you opened the topic, I will just give you. In the year 2013, the government of India brought the what we call as the Criminal Amendment Act. Because they brought the Amendment Act because the rape cases and atrocities on women was going up like anything. And in circumstances such as this, the Supreme Court was also studying this, because when the cases come up, they ask the concerned pleaders, argue the case before them, give this statistic, and these days it has increased. And they will be asking material on everything. It is more than the argument which they make before the court, because they want to know what exactly the present status. So study the law, present law, and then try to find out the weaknesses in the law and what exactly are the loopholes. And a few gray areas will come wherein difficult to give certain measures. Wherein there are certain areas wherein you have the law but which is not made applicable here. That is how, remember, solution is brought out.
Right, sir. Thank you, sir. Sir, just to connect with this one, may I ask a small question further with connecting with the same? Yeah. So the point is that when we speak about like Stockholm Declaration is a very important topic that you have mentioned already. And suppose if we make a, like a data for last 50 years, like regarding successful implementation in various countries. So one of the important parameter could be like how the environmental right being considered as human rights, because that was one of the important aspects of Stockholm Declaration. So how should we design the action research methodology to do a proper research in this sector?
Say, um, uh, Professor Sohn of the Harvard Law School, he has written an article on the Stockholm Declaration itself. And in the article, it was published in the Harvard Law Journal, and Louis B. Sohn. Now, because I was trying to get the name. Now, in the article, what he points out is what is the binding nature of the Stockholm Declaration. And when he was saying, remember, he points out before the Stockholm Declaration was adopted, the Committee on Environment and Development, which was, they are the ones who were in a position to call a meeting of this nature, had sent letters to almost all the countries of the world. Then there were about 160. And they said, remember, you have to submit a report on the following. And the report is only on the status of environment. The status of environment in India, state of environment in other countries. Those who are members of the United Nations were asked. And how many species you have? How many of the best of the species, which are rarest of the rare, have disappeared? Have you taken steps to, remember, rejuvenate and bring in these species? Like this. I'm just giving you one raw example. On all matters, they asked. Then the report was independently studied. And the report was independently studied. Then they said the need of the hour is to have action on this. That is how United Nations Environment Program came in. Get the point? And 21 principles, he points out, they are the authoritative principles of the Charter of United Nations. This is what I wanted to tell. They are the authoritative principles of the Charter of United Nations because it is part of it. And even if you say jus cogens, nothing is going to happen. There are people who may not accept. If you say it is jus cogens, because jus cogens are only two. There are only two principles of international law today to regard and consider jus cogens. One is piracy, and the second is war crimes. Others, they are near to it, but they are not part of it. This is how. But then in this article, he was saying they express the common consciousness of the people around the world, authoritative interpretation of the Charter. And he has written on Universal Declaration of Human Rights also. And this person in the Universal Declaration of Human Rights also, he was saying the first 21 articles of the Universal Declaration of Human Rights, which express civil and political rights, are the authoritative interpretation of the Charter. This was written much earlier, but this was written later. This is it.
Yes, sir. Many thanks. I think that really gives the kind of the analysis about how to design the research methodology when we are going to undertake the action research altogether, because it has been seen also like how to improve basically or reform in the alternative dispute resolution sector in the legal practices. I think action research methodologies are very, very important in that regard.
See, one point I just wanted to tell you. Up to 1976, there was no environmental law in this country. And environmental law came in, this is because of the Stockholm Conference. And Mrs. Gandhi herself went there and spoke in Sweden. Palme was the Prime Minister of the State of England. And she delivered one of the best speeches of her life there. And then National Committee on Coordination was appointed by the Government of India. The National Committee on Coordination, first it was composed of 14 members. And they were all eminent men, and a few of them were civil servants. And it was very effectively functioning. They were requested to draft, remember, a legislation on this subject. That is how it came in at a later stage. First it became 14, then it became 24, then it became 27, then it became 37. Then it became a den of retired civil servants that had to be put to an end, and then the Environment Protection Act came in. This is the history of the environmental law in India.